record, the prospective jurors have raised their hands in the affirmative. Are all of you residents of Leon County? Please raise your hand if this is true. Again, the prospective jurors have raised their hands. Thank you. Do each of you possess a driver's license or identification card that's been issued by the Department of Highway Safety and Motor Vehicles, or have you executed an affidavit as to your eligibility to serve as a juror? Please raise your hands. Once again, for the record, the prospective jurors have raised their hands in the affirmative. The next series of questions are basically just going to deal with whether anyone should be excused at this point or is ineligible to serve. Has anyone been previously convicted in a state or federal court of any felony crime or a crime of dishonesty and you have not had your rights restored to you? If this describes your situation, please raise your hand. For the record, none of the prospective jurors have raised their hands. Are any of you at this time under current prosecution for any crime, either in a state or a federal court? Please raise your hands if this describes your situation. Once again, for the record, none of the prospective jurors have raised their hands. As to matters in which you can be excused by law, is any person here a sworn federal, state, or local law enforcement officer or investigative personnel? No hands have been raised in response to the court's questions. Is anyone an expecting mother or a parent responsible for the full-time care of a child under 6 years of age? All right. Sir, if that is, please form a line and I will deal with you momentarily just in the middle. Is anyone present 70 years of age or older? No hands have been raised in response to this question. Has anyone performed state jury service within the last year? And by last year, what I'm referring to would be August 19th, 2024 to today. No hands have been raised in response to that question. Is anyone responsible for the full-time care of a person with a physical or mental incapacity who is incapable of caring for themselves, and your presence will create a hardship? No one has responded in the affirmative to that question. Is anyone a full-time student between the ages of 18 and 21 years of age who is attending a high school, state university, private post-secondary educational institution, Florida college system institution, or career center? Right, if you please can stand behind the gentleman in the aisle. I believe we also have one new one by statute. Has anyone given birth within the 6 months before the reporting date on your summons, and you are seeking to be excused for that reason? No hands have been raised in response. Right, one by one, if you please can come forward, and I will address the issue in which you responded to your questions, or to the court's questions, I should say. If the attorneys wish to listen to the court's conversation with the prospective juror, you can. All right, now that we've settled the issues of who is eligible to serve and actually remain, we are going to proceed with the process this morning. The first thing that we are going to do is to discuss what you may know about this case, if you've heard anything about it at all. This case has received some publicity, and there also was a related case that took place almost 2 years ago. This process is going to be handled individually because you will not need to know what others may already know concerning this matter. However, before we start that questioning, I am going to give you some very important instructions. Many of you have cell phones, computers, and other electronic devices with you. Even though you have not yet been selected as a juror in this case, there are some rules that you must follow about using your cell phones, electronic devices, and computers from this point moving forward. You must not use your phones or devices to search the internet or to find out anything that is related to this case. Between now and when you have actually been discharged from jury selection or jury duty, you must not provide or receive any information about your jury service to anyone, including friends, coworkers, and family members. You may tell those who need to know where you are that you have been called for jury duty. If you are picked for the jury, you may tell people that you have been selected for the jury and how long the case may take. However, you must not give anyone any information about the case itself or the people that are involved in this case. You must also warn people not to try to say anything to you or write to you about your jury service or the case itself. This includes face-to-face interactions, phone or computer communications. In this age of electronic communication, I want to stress to you that you must not use electronic devices or computers to talk about this case. This would include tweeting, texting, blogging, emailing, posting information on a website or chat room, or through any other means at all. Do not send or accept any messages, including email and text messages about your jury service. You must not disclose your thoughts about your jury service or ask for any advice on how to decide the case. Further, you must not read nor listen to any news accounts about the case until you have been excused in this matter. Please avoid the newspaper and television broadcast, particularly the local news stations. Also, avoid any social media or any internet news sites concerning this matter as well. Mr. Zellman, if you still have the statement of case on your computer, I will just read it from that. You may. I'm going to read to you at this time a statement of the case that has been agreed upon by the parties. On July 18th, 2014, FSU College of Law Professor Dan Markel was shot while seated in his car. This happened in the driveway of Markel's home on Trescott Drive in the Benton Hills neighborhood. The killers traveled to Tallahassee from Miami to commit the murder in a rented silver green color Prius. The defendant and alleged conspirator in this murder was the former mother-in-law of Dan Markel. She has entered a plea of not guilty. The statement of the case that I have just read to you is not evidence, and it's not to be considered by you as evidence or any proof of guilt. You must not be influenced by this statement. It is merely informing you of the accusation that has been made by the state against the defendant. Before we speak with you individually and privately about this case, some of you may be excused. Mr. Zellman, you can take it. I'm also going to read to you at this time the material part of the indictment that has been filed against the defendant. Once again, the indictment is not evidence, and it's not to be considered as evidence or any proof of guilt. You must not be influenced by the fact that an indictment has been filed in this case. It is merely a formal method by which the state makes an accusation against the defendant. It is alleged in count 1 that on or about July 18, 2014, Donna S. Adelson in the county, Leon, and state of Florida did unlawfully kill a human being, Daniel Markel, by shooting with a firearm, and the killing was perpetrated from or with a premeditated design or intent to effect the death of Daniel Markel, contrary to the Florida statutes. Count 2. Beginning in 2013 and until October 1st of 2016, Donna S. Adelson in the county of Leon and state of Florida did agree, conspire, combine, or confederate with Charles Adelson and or Catherine McBanois and or other persons to commit first-degree murder, contrary to the Florida statutes. Count 3. It is alleged that beginning in 2013 and until October 1st of 2016, Donna S. Adelson in the county of Leon and state of Florida did solicit another to commit first-degree murder, and in the course of such solicitation, commanded, encouraged, hired, or requested the person, Charles Adelson and or Catherine McBanois, and or other persons to engage in specific conduct which would constitute first-degree murder, which resulted in the death of Daniel Markel, contrary to the Florida statutes. I believe I said this before, but we are now going to speak with each of you individually and privately about this matter. Some of you may be excused during this process. The rest of you will remain to participate in the next phase of the jury selection process. Individual voir dire is time consuming, but will go a lot smoother if you are prepared to tell us what we need to know. The basic questions that you will be asked are the following. Number 1, what do you know about this case? Number 2, what sources have you obtained this knowledge from? Number 3, based on what you know, do you have an opinion about Mrs. Adelson's guilt or innocence? Number 4, can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence presented in the courtroom? Can you be fair and impartial? Number 5, do you have any reason that you cannot serve on this jury for potentially up to 3 weeks? It will save us all a lot of time if you think about these 5 questions and you are prepared to give a prompt answer when you are called back. We are going to discuss one thing with you individually, specifically as it relates to the hardship of serving on this jury. We expect the jury selection process to take until Thursday of this week. After that process is complete, we expect the trial to start on Friday and potentially go for 2 weeks after that. All in total, we expect the proceedings from today may take up to 3 weeks. We understand that is a burden for anyone to serve for that length of time. However, we cannot make our system of justice work unless we have good people that are willing to do their civic duty as jurors. Similar to military service, we will have to call on our citizens at times to make sacrifices. Jury duty is one of those times. You will probably never be called upon again for something of this nature to serve in a lengthy trial. I understand for some of you, this may not be possible under the circumstances. To give you a little more information about what this will involve, you are not going to be sequestered during the trial, meaning you will be capable of going home and returning to the courthouse each day. For the most part, we will work a regular business day, but on occasion it may be necessary to work a little bit longer based on the witness schedules. I will do my best to adhere to a regular schedule so it will not disrupt your lives. Please give some thoughts as to whether any of you may have a major problem, including a physical issue, that would prevent you from giving this case your full attention and performing your duties as a juror. Please be patient with us as we will be working as efficiently as possible. The bailiffs, the clerks, and court administration will be assisting here in the courtroom. Please follow the bailiff's or clerk's instructions. You are not to discuss this case while you are waiting or anywhere else until you have been excused. Also as well, there is reading material that has been provided by the court in the form of some magazines that are available to you if you would like to read. You also may look at your phones, but you are not to speak to each other or have any conversations about the case or anything else. For this instruction, does anyone have a question? Because I want to clear this up before we get underway. Again, you are not to speak to each other. You are not to discuss the case. You may look at your phones. You are not to look at any material that is related to this case. You also may read the reading material that has been provided by the court. Please do not listen to or read any media accounts on your phone or anywhere else until you have been excused. We will begin with the individual process at this point. If the parties, please, can relocate to the jury room. We will call each of you by your number, and from there, we will go through the individual screening. If the bailiffs also can position themselves through the room as need be to make sure the orders are going to be enforced.
All right. 14A District Court, County Washington, State of Michigan is now in session. For the court drawn near, the Honorable Judge Dave Cedric Simpson presides.
You may be seated. Oh, you lost the coin flip. Okay, Ms. Zenda.
Good morning, Your Honor. As and on behalf of the people, Your Honor, the people have waived any potential conflict between this honorable court and the Office of Public Defender. While the people don't believe such conflict exists, we make this waiver in avoidance of all doubt.
Mr. Brown, haven't heard from you in a while.
Good morning, Your
Didn't
Honor.
have somebody to do this for you.
Man, I couldn't find it.
All right, let's see if you remember. Go ahead, sir.
Lauren Brown, Deputy Chief Public Defender. Your Honor, likewise, we do not believe that a conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflict so that this honorable court could hear these matters.
Thank you, sir. And the court, for its part, does not believe there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Valerie Johnson. Got it.
Joseph and Government People, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Johnson. Ms. Johnson, can you state your name for the record?
Valerie Johnson.
Your Honor, I have an application pending to schedule a meeting with Ms. Johnson, so I'd ask for an adjournment for that purpose.
That objection, how much time? You have the application.
The application is pending, but I already have, I guess, my video visits approved. So once, it shouldn't be very long, I can expect. That makes
Yeah,
sense.
okay, I believe that. All right, probable cause conference will be here on September 4th,
Thank you.
2025, 9 a.m. Bond will continue. Thank you, Ms. Johnson.
Thank you.
Senator Gregg here.
Court. Really? No, go ahead. I'll wait. You got everybody? Court does call the case of the people versus Michelle Lovaz.
John Shea, Your Honor, with and on behalf of Ms. Labaz, who's approaching.
Morning, what's your name?
State your name for the record.
Michelle Lavaz.
Thank you. All right, what do we do?
Your Honor, the defense has been awaiting supplemental medical records for quite some time. Medical records take a long time to obtain. My understanding is the prosecutor's office has them. They will be tendering them to us. We will be tendering them to others who need to review them. I'm going to be out of the country between August 31st and September 19th, so we're requesting a PCC until after that.
Since September 19th.
Yes, sir.
You come back. I can do September 25th or October 2nd.
Your Honor, September the 25th will work just fine. At the 22nd, excuse me one second, Your Honor. Your Honor, it's September 25th for the time being. We may have a conflict with that, but if we do, we'll contact the court. I know I have a conflict on the 2nd.
Hearing no objection, probable cause conference, September 25th, 2025, 9 a.m. Bond continued.
Thank you very much.
Thank you, Your Honor.
Court calls case People versus Samuel Klosky.
And then on behalf of the people, Your Honor.
Everybody see Mr. Jerkus? I'm sure he did.
I go fine.
Where is he? I realize, Miss Cannon, you were trying to stand in my eyesight, so I know that you're actually here and we're waiting on somebody else. No, never mind. You don't have to say anything. I'm just saying, I get why you're there.
My apologies, Judge.
Your name, sir?
What's your name? Samuel Klosky.
Thank you.
Your Honor, we are asking that this matter be set for preliminary exam.
All discovery complete?
To my knowledge, yes.
People have their witnesses available the 2nd.
We'll do our best, Your Honor.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Freshour.
Thank you, Judge. Thanks, Your Honor. All right.
Bond continued. Court calls case People versus Eric Lightheart.
Morning, Your Honor. Christopher Shemke appearing on behalf of my client who approaches.
Your name, sir?
Eric Blackhart.
Thank you. We're doing, you're seeking an adjournment?
Yes, Your Honor. I'll have that go off.
That objection, probable cause conference will be adjourned to September 2nd, or September 4th, excuse me.
Your Honor, if possible, I was respectfully requesting consideration for the 18th of September. I fully expect the matter to find a resolution. I do not see this matter being set for an exam.
5 weeks out.
But I wouldn't be seeking any additional adjournments.
Any objection from the people? September 18th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you.
Court calls case People versus Kyle Beckerman.
Good morning, I'm pleased Honorable Court David Burgess on behalf of Mr. Beckman. We got our discoveries complete. We're requesting exam on this matter.
Your name, sir?
Kyle Beckerman.
People have their witnesses available the second. Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Perry. Bond will continue. Court calls the case of the people versus Latanya Marie, I'm sorry. Yeah, Latanya Marie Lee. Let's see, get that wrong. Naya Lee, they have it. They have those.
Andrew Childers, appearing on behalf of people. Good morning, Your Honor. Sam Bernstein with on behalf of Ms. Lee. Ms. Lee, could you please state your name?
Naya Lee.
Your Honor, we're asking for an adjournment. There's some discovery that still needs to be produced, and we're working on a resolution. So a lengthier adjournment would be appreciated, Your Honor. Respectfully requested.
The 4th.
Like a 30-ish.
Pardon?
You said to the 4th, Your Honor? Could be a little
If
bit
I'm giving suggestions. Go ahead.
like the 18th, Your Honor, please.
18th, why? That's 5 weeks out. The other one was a retail fraud. I don't even understand why we sent that out 5 weeks. And this is,
Yeah, I guess that is a little bit lengthy. September 11th, Your Honor.
September 11th, 2025, 9 a.m. Bond continued.
Okay.
Court calls the case of the people versus Christopher Decker.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Decker, who approaches. Please state your name.
Christopher Decker. All right, you're requesting a forensic exam.
Yes, Your Honor. I met with Mr. Decker. There were some concerns raised during our meeting Saturday, so we're requesting a forensic exam. I've received the paper discovery from the people. The prosecutor also has provided me the email address, and I already sent over a request while waiting to be called for the digital discovery. I think the only holdup is how long it'd take to get the forensic center to see my client.
Forensic examination evaluation is ordered. I'll set a competency here, give me 90. We'll move it up. Yes, sir. November 13th, 2025, 9 a.m.
And Your Honor, my understanding is, I don't believe bond's been addressed in this, and we just asked the court to reserve that. There's a revoked bond from a case that's already been bound over to circuit court, so I don't believe any of this time is counting on this case. But we just didn't want the court to deny bond or take any further action until we get a response back.
He's got a 25,000 cash shirt.
On this case, thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the people versus Carlton Cross.
Yes, sir.
Mr. Feaster's case.
Lauren Brown, Deputy Chief Public Defender, placeholder.
Sir, can you state your name, please?
Yes, sir. Cross and Deion Cross.
Thank you.
Brother Judge, Portia Feaster, Assistant Public Defender.
Thank you for joining us.
Apologies.
What are we doing in this?
Thank you, Judge. I've been trying to work with the prosecutor to receive an offer on this case. I believe it's the first PCC. We have not yet received that offer. I will request a brief adjournment to see if there is an offer we can possibly get to resolve this.
That objection, August 28th, 2025.
Thank you, Judge.
Bond continued. Thank you, Mr. Cross.
And sir. Judge
I'll come
Simpson.
down and talk to you, Mr. Cross.
Okay, and Judge Simpson, And I've already, on my other case, I've already been, uh, released the treatment. And I'm just waiting for, Miss Sarah at correctional, service to come down and talk to me.
Okay, I'm sure that'll happen. Okay, and if there isn't an order on this case, they can prepare an order and I'll sign off so that this case doesn't hold you up, okay?
All right, thank you so much, sir.
Thank you.
Have a good day.
You do the same. Court calls the case, People versus DeLorean Hall. So,
Joseph, another people, Your Honor.
Morning, Your Honor. Sam Bernstein with on behalf of Mr. Duhall. Mr. Duhall, could you please state your name for the court?
DeLorean Duro.
Sorry, apologize. Your Honor, two things. First, I had spoken with Mr. Dural about setting this for exam, but in reviewing the discovery after we spoke, I realized that there's some more discovery that I would need before setting it for exam, so it's not there quite yet. I still have to fill out a green sheet for Your Honor, but I'm asking for a short adjournment to do that, please.
August 28th, 2025, 9 a.m. I'll need a green sheet. Bound will continue.
Judge, I was hoping to address bond for Mr. Dural. Your Honor, Mr. Dural suggests that he has a number of community supports and stability of the community that would allow him to be monitored safely. He does live with his father in Southgate. His father is a business owner and he works for him. He is being groomed to take over a management position there, and he's made a lot of strides there. He also works full-time at McDonald's, 10 to 6 weekdays, Your Honor, and he has a 4-month-old baby at home. He is asking the court's consideration for bond review.
Response. I'm sorry, I did not hear any of that last part.
I believe, Your Honor, the bond has set is appropriate given the nature of the charges that I'm facing. I was hoping of this. But given the fact that this defendant is charged with armed robbery, I think the bond is appropriate as set. People for the court to make further determination.
At this point, what I'm gonna do is I'm gonna deny the motion to modify the bond in this case. The bond will continue, however, Mr. Bernstein, if you'd like to file a written response so I can get more information, since I didn't get any for the people, I'll be more than happy to consider it.
We'll do that, Your Honor. Thank you.
Court calls case People versus Alexander Sanchez Garcia.
Good morning, Your Honor. Nicholas Monterez on behalf of Mr. Alexander Sanchez Garcia, present to my right. Mr. Sanchez Garcia, can you state your full name for the record?
Alexander Sanchez Garcia.
Thank you. You're requesting an adjournment.
I am, Your Honor, and I spoke with the people before stepping up to the lectern here. If the court would like more information, because the green sheet is a bit vague, then I'm happy to give it, but the people and I, we're asking for 3 to 4 weeks, Your Honor.
That objection, probable cause will be adjourned September 11th, 2025, 9 a.m.
Thank you, Your Honor.
Bound continue.
Thank you, Your Honor.
Court does call the cases of the People versus Todd Reberg.
Andrew Childress, people.
Carl Verdell appearing on behalf of Mr. Reberg in the case ending in 5649.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Rayberg in all his other matters. Mr. Rayberg, could you state your name for the court?
Todd Rayberg.
Thank you.
And Your Honor, I would ask you to approach on these matters.
Come on.
Thank you.
Judge. The judge just go through the treatment, so they are still not getting into facilities.
All right, record should reflect we had a bench conference in this case. You're seeking an adjournment.
Yes, Your Honor.
Yes, Judge. Because he's still awaiting potential release to treatment.
Yes, Your Honor.
What, the 4th or the 11th, Ms. Young?
Yeah, either works for me, Judge.
Either, Your Honor.
Did I ask for Dell? Did I say Ms. Young?
Oh.
Dell thought I cared. No.
Probably the 11th, Your Honor.
Yes.
Thank you.
She's still doing great.
I am.
Probable cause in this matter will be adjourned to September 11th, 2025, 9 a.m.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor. Keep your head up top. Thank you.
Court does call the case of the People versus Nolan Hearns. Your Honor.
Good morning, Your Honor. James Feifelsky appearing with and on behalf of Mr. Hearns. Can you state your name, please, sir?
Nolan. Oh, you just says.
Yeah. Your Honor, I'm asking for a brief 1-week adjournment for the video discovery, which I believe is forthcoming, and set this for PCC out at the next available date.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continued.
Thank you very much, Your Honor. August 20th.
Okay. The court calls the cases of the People versus Debbie Ann Langford.
And then we got people, Your Honor.
Sherilyn Foster Tucker on behalf of Davion Langford.
Davion Langford.
Thank you.
Your Honor, I am just jumping in on this case. I'm just requesting a brief adjournment to get discovery and review it with my client.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case People versus Test for Michael, Test for Miriam.
Joseph Pagano, people, Your Honor. Good morning again, Your Honor. James Feifelsky appearing on behalf of Mr. Tess Maramian, who is approaching. Come on up, sir. Please state your judge.
Tess Maramian, Tess Maramian.
I'm sorry.
My name is Tess Maramian, Tess Maramian.
Your Honor, we are simply asking the court to set this for preliminary examination. I believe I have all of the discovery, and then I can address the community corrections issue.
Why don't we address the community corrections violation now?
Yes, Your Honor. There is a slight language barrier with my client. He does have a green card, but he's from the country of Eritrea, I believe it is. He tells me that he didn't receive any paperwork when he was released from custody, so he didn't know exactly what to do. When I got the notice of the violation from community corrections, I advised him to go over there. He said he did go over there twice yesterday, asking to be enrolled in the intake process. He said that they told him they didn't have any paperwork for him to do that. So he's happy to do that right now.
That's not true.
I don't think there'll be any problems.
It's not
but
true. There's
Okay.
paperwork over there. I can see the paperwork over there. And if they didn't have paperwork, they wouldn't have sent the bond violation. He's not telling you the truth.
I did.
Well, I apologize, Your Honor, on his behalf. He tells me there shouldn't be any issues if the court wouldn't mind passing hit for him to do.
When did he say he went over there? Because I'll call right now.
Yesterday.
Yesterday afternoon?
Yeah.
They wouldn't have. It's not true.
I did.
I can, because I've got the bond violation here from me.
Okay. This is his first experience on this level with the legal system. So I would ask.
Probable cause conference will be adjourned August 28th, 2025, 9 AM. At this time, the defendant's bond is revoked. Defendant's remanded. Are they ready? Court does call the case, People versus Carlos Sell.
Albert hearing on Mr. Self, who's approaching the podium as we speak. Carlos, once you get up here, introduce yourself to his honor.
Carlos Sell.
Thank you, Your Honor. I had previously represented Mr. Self in the matter ending in 5140. Late yesterday, I was just appointed to his other matter, 5186. We are asking that both matters be adjourned in order for me to review discovery and work on a global resolution with the people.
Probable cause conference in these cases will be adjourned August 28, 2025, 9 AM. Bond continue.
Thank you, Judge. Defense may be heard as to bond.
Go ahead.
So, Your Honor, Mr. Self had previously received a bench warrant in the case ending in 5140. That's because he was in the hospital with extremely high blood pressure. He tried to leave. He tried to get his doctors to let him go, but the doctors said, well, you can stay here or you can go to court and have a stroke due to his extremely high blood pressure. So he opted to protect his health and stay. So unfortunately, he was predisposed. He did have his intake paperwork. I asked him to provide it for me, but unfortunately that was lost when your apartment flooded, was it?
Yeah.
So his apartment flooded and destroyed a lot of his belongings. So unfortunately, we don't have documentation for the court. He is also interested in.
Was that explained the cocaine use during July?
I don't believe that would be related, Judge, to that particular issue. But we have reached out to Sarah Stewart in the jail about getting into Dawn Farm in-jail treatment program. Mr. Self is a business owner. He owns a barbershop. He's eager to get back to work. He has 3 employees who rely on him for their livelihood, in addition to his own livelihood at the shop. The shop is currently closed and idled while he is in custody. So we are asking that he be released to be able to return to being a productive member of community and a job provider for the local community. And so we are asking for a PR bond on these matters.
I don't need a response from the people. His bond will continue as previous, as I've said it. In this case, motion for bond reduction is denied.
Understood. Thank you, Judge.
Court does call the case of People versus Vincent Lambert.
Morning, Your Honor. Public Defender, let me sub on behalf of Mr. Lambert.
Mr. Lambert, can you state your name, please?
Vincent Lambert.
Thank you, sir. What are we doing?
I'm requesting an adjournment. Your Honor, we are missing some video. I did re-request it yesterday, and as of this morning, Mr. Childers did advise me that it should be released, so we just have to extract it and watch it.
Give you my next available date, August 28, 2025, 9 AM.
Thank you, Your Honor.
What was your name,
Thank
ma'am,
you.
so I can call you and ask you a question?
He's talking to you.
It's Miss Saab. Like the car, Saab.
Miss Saab, thank you very
Saab,
much.
not Audi. Trying to make that clear. Court calls the case, People versus William Bastable.
Joseph, people, Your Honor.
Mr. Denua,
Hi, be next door.
really? You do me any good.
Hello. I've been. How are you?
Oh, do you know what you're doing on your case today? Did you adjourn or you said?
What's he saying? He might adjourn on video.
Video, okay.
Sorry, Your Honor. Assistant Public Defender Ben Denowith on behalf of Mr. Bastable. Your Honor, the defense is asking to adjourn a week. We've not received the video discovery. My emails of Friday and Monday were not returned. We cannot conduct the preliminary exam without the video that is referenced in the police report. So we'd ask to adjourn for a week. I do have the form in my bag.
Well, I'll need the form.
Okay.
Without objection, probable cause conference, August 28, 2025. 9 AM, bond will continue. Court does call the case People versus Tanya Hall.
Good morning, Our object going back from this hall. Tanya.
Tanya Hall.
Judge, I've just been speaking with the prosecutor in this matter. I believe we're going to work out an agreement where she's going to be allowed to plead to a misdemeanor. My understanding, we don't have a plea form today, so we're asking for a very short adjournment so we can do that.
Has she been counsel approached?
I believe we have a plea worked out. We need to do the paperwork. We're asking if we could set this matter for the 28th.
All right. I will adjourn this matter out August 28th, 2025, 9 a.m. Bond continued. Okay, Ms. Hall, we'll see.
Yes, sir.
You can get back on the 28th.
Yeah.
That's- you- Okay.
Court does call the case People versus Brian Gerard.
Assistant Public Defender, let me stop on behalf of Mr. Gerard. Your Honor, we are asking to set this for preliminary exam, and to my knowledge, discovery is complete.
Sir, your name?
Brian Gerard.
People have their witnesses available the second. Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Thank you.
Court calls the case of the People versus Ronald Lucky.
Josephine Gilman, speaking, Your Honor.
Morning. Judge, in this matter, we'd like to set this matter for a preliminary exam.
Your name, sir?
I'm Ronald James Lucky.
Discovery is complete, Mr. Kidwell.
Yes, Your Honor.
People have their witnesses available the second. Preliminary examination, September 2nd, 2025, 9 a.m. That is before Judge Perry.
Judge, may I address an issue? Mr. Lucky was staying where the incident, the allegations against him. He was renting a space at 1074 East Forest. He's not allowed to go there. All his worldly possessions are there. He has tried numerous civil standbys. He said he even got a court order that he could get his belongings. Can you be of any assistance, him getting his property from there?
I'm not moving anything, if that's what you're asking.
Pardon me? No, I'm not asking you to help move them. No, not, you know, that.
Judge Otis.
Well,
Ordered it in writing.
who ordered it?
The one that let me out on bond, I believe Judge Otis, they wrote it down on a
No,
post, you know.
It's a Odetella.
I'm
It's a
sorry.
magistrate.
I'm sorry. I didn't have my
I'm
glasses.
gonna tell him you called him Otis, though.
I'm sorry.
Funny.
Right, right.
Right.
Like the elevator. You have an order that allows civil standby.
He said he was issuing a written order for me to have access to my property. That's what he said on Zoom when I got bonded out.
Has he issued it?
He said he did. I was in custody. I didn't have a pen, a paper, a case number. I have nothing.
Would that be reflective in the file, Your Honor?
I don't see an order. Mr. Killowell, if you prepare an order permitting civil standby to that address to retrieve his property, I'll sign off on it. I don't know.
Okay.
Sure.
All right.
Nothing.
Huh?
Sheriff's done nothing. I've been there more than 10 times with the owner. There's witnesses.
We'll have a court order.
Thank you.
If he gets a court order, I'll sign off, sir. It'd have to be done today, otherwise I'm out for about a week, so.
I'll have it done this afternoon.
All right.
Thank you.
All right, thank you, Your Honor. Do we set the, oh yeah, we did say.
Also, the court
Wait a
keeps
minute,
me
hold on.
on that address.
Okay, we're gonna take care of it.
September 2nd.
Yeah. September 2nd.
Court call stays. People versus Nathan Gabachi. Tell Otis he needs to do an order.
Andrew Childers, appearing on behalf of the people.
Good morning, Your Honor. Alex Warren Green on behalf of Mr. Gabachi. Could you please state your name, sir?
Nathan Gubachi.
Thank you.
Your Honor, at this time, we are asking the court to set the matter for preliminary examination.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available to second. Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Freshour. Bonds will continue.
Your Honor.
Court calls case People versus Ashley Nader.
And then I have the people, Your Honor. That's Mr.
Yeah.
Morning, Your Honor. Rob J. Kill on behalf of. Judge, in this matter, we're asking.
Your name, ma'am.
Ashley Nader.
Nader. I'm sorry, Judge.
No, it's okay.
Judge. Sure.
That was to you or me?
I was just.
You were answering for me, Killawall?
Judge, I'm not sure where I am this morning.
Okay. Wait, that leads to confidence for your clients. Come on.
He wants you to go take ET.
You know, and also me too, you know, to an extent. Adam Christopher Lang Senior.
Mr. Lang, good morning. Could you please let the jury know what your occupation is?
I sell pharmaceuticals for the past 20 years, medical devices. That's why I'm in scrubs today.
So are you headed for an appointment right after this?
Yes, I have my sales manager as well as a customer appointment after this.
Adam, how do you know Andrea?
I met Andrea about 7 years ago. I hired her as my real estate agent to sell my family home after my divorce.
And
Now, was this interview videotaped?
It was.
Okay. And at this point in time, was Mr. Waffenbach under arrest at all?
No.
Okay. And did he speak to you?
Yes, you did.
Now, have you had the opportunity to view this videotape in preparation for your testimony?
I did.
Now, tell the jury about the sound quality on this particular video.
So I did view the video and the sound, at least on the device that I was listening to, is very difficult to hear for myself. I have a report, so I was reviewing the notes of it. It seems to correspond, but again, the audio is difficult for me to comprehend.
Okay. And have you had opportunity to listen to it and watch it in preparation for your testimony today?
I did.
All right. Permission to approach your honor? Granted.
Get ready, guys. We have bad audio. We have to listen to bad audio.
I'm going to put was the Mark Stacy Exhibit 72. Tell me if you recognize this Exhibit 72.
This is, yes, I did.
How do you recognize it?
I initial and dated it.
Is that the 2001 video that we were just referencing?
Yes, I did.
And does that video appear to be a fair and accurate depiction of the interview you conducted with Mr. Waffenbarger in September 2001?
Yes.
Do it appear to be any additions or deletions?
No.
Around this time, the state would like to admit Exhibit 72.
Mr. McGovern, Mr. Seaman? No objection. 72 is admitted.
Thank you. And permission to publish.
Here we
Permission
go.
granted.
And we'll slow it down to try to listen. Get ready.
Bedroom 70%. Connected to UATBR 54102682.
Oh, God. All right, we might have to boost this. Shout out to Nick Staro's chat. You keep. Let's see how this volume is. Oh God.
Is this the interview? It is pretty much the sound quality throughout the most of the video. Okay. Did you take notes about your conversation with Mr. Wolfenbarger?
Yes, I did.
Okay. So when you met with him, was he able to give you kind of a history of when they first met?
Yes.
Okay. What did he tell you about when they first met?
He said that he first met Melissa when she was 15.
And did he tell you how he had met her?
He said that she had run away from home, but I don't recall any, details much beyond that.
And was he able to tell you whether or not they were married or not?
Yes.
Were they married?
Yes, they were.
Okay. And when did they get married?
And he said 1992 or 95.
Okay. He said 92 or 95.
And I noted 95, I believe, in my report. So I don't know if we clarified that.
Did you not notate him saying? This is where the prosecution should ask more specific questions. Did you notate in your report that at first he said 92 or 95 and then corrected himself? Or is the only thing notated in your report that he said 95? And now today on the stand, you're deciding that this guy had a 3-year gap in when he got married.
Was he able to tell you if they had children?
Yes.
And how many children did he tell you that they had?
2.
Now, did he tell you about where they lived?
He did.
Okay. And where did he tell you that they lived?
I believe they were living with his mother at that time.
Did there ever come a time where they moved from his family's home?
I don't see a notation for that. I don't recall that.
Do you recall him telling you that they lived at 824 Brookline Street in Atlanta, Georgia?
Yes.
Okay. Is that contained within your report?
Yes.
Okay. Did he tell you about where he worked?
I think he did discuss some of his employment. Let me check the notes for clarification. Yes, he was working for a glass company.
And did he tell you where the glass company was?
I don't have a notation for that.
Okay. You're on permission to approach?
Permission granted.
Hilton asking for permission to approach killed me because of Woody. Oh. And I heard, I don't know if CMT is in the chat, but CMT said Maurice is on the camera.
Is that a summary of your interview with Mr. Wolfenbarger?
Yes, it is.
Okay, I'm going to direct you to this line right here.
Yes, I did see that. He provided that the glass company was on Avon Street, but I don't have a city or any other location for it.
And did he tell you about where Melissa worked?
Yes.
Where did he tell you Melissa worked?
On Waffle House in Doorville.
Now, did he discuss to you about his relationship with Melissa around November, December of 1990?
Yes.
What do you recall him telling you about his relationship with Melissa around that time?
That they were together around the November, December timeframe of 98.
Did he tell you anything about being separated but then getting back together? God bless you.
He stated that they were together for about a month in that time, and so I don't want to misstate your question. I don't know that we discussed so much being separate. He just indicated they were together for about a month, which might imply that. But
I'm gonna approach again.
You don't have to ask every time for the same witness. Thank you.
Like I say, that he did indicate they were separated. They gotten together for about a month at that time.
Okay. Ms.
But you-
Hilton, I'm sorry for interrupting. Can you take down the screen share, please?
Oh, sure.
Thank you.
But did you notate that he told you they got separated but got back together around Thanksgiving 1998?
Yes.
All right. And then according to him, did he tell you when Melissa moved out?
Yes.
When did he tell you that she moved out?
Around Christmas of 1998.
All right. Now, after she moved out, did he tell you if he ever saw Melissa again?
He did.
Okay. What did he tell you about when he saw Melissa again?
He stated that he saw Melissa walking on Lee Street in Atlanta several months after that she had left, so sometime in 1999.
Okay. Do you recall him telling you approximate month about when he saw her in 1999?
I don't recall it. I'll review the report.
Do you recall him telling you it was between either March or April of 1999?
I don't recall that, and
What? Hilton?
don't know that I notated the specific month.
What did he tell you about when he saw her in 1999?
That she was walking on Lee Street, that she didn't look particularly well, that had indications of possible drug use.
Was he able to tell you if she was with someone, dating someone?
She said he didn't say that she was with someone walking, but he did say that she may have been involved with someone named Mike, whom she worked with at the Waffle House in Dover.
In 2001, regarding the last time he saw her, did he only tell you that he saw her walking down the street?
Yes.
Did he tell you about anything about where she was going?
No.
Did he tell you, if you can recall, about what their conversation was?
No.
Did he tell you why he never made a report as to why she was missing?
No.
Did he tell you anything about whether or not he contacted her family to let them know that she was missing?
He stated that he didn't contact her family, or wasn't in contact with her family.
Did he give you a reason why he didn't contact her family?
He stated that they did not get along or they didn't like him.
Whisper, whisper.
This juncture, when you interviewed him, do you know where he was living?
In case I have, he stated he lived at 824 Brookline.
Did you have an address that you notated in your report for him at the bottom of your report?
507 Kenny Drive, Hinesville.
Okay. So at the time, do you know if he was still living on Brookline or if he was living on
I
Hinesville?
don't know. The report, it may be referencing that he stated that, or they lived at Brookline, so maybe when they're together, they were Brookline, maybe he was at this other address.
I couldn't. Sorry, you're actually getting in front of the microphone.
sorry.
That's okay.
Apparently, in the report, I indicated that he and Melissa both lived on Brookline, and at the end, I have a different address, so that Brookline address may have been referenced to when they were together.
Thank you.
And is it safe to say that what you have in your report is a summary of parts of that interview?
These are bullet points.
And would the interview contain everything that you all actually discussed?
That's right.
After speaking with Mr. Wolfenbarger, did you speak with any of his family?
Yes.
And who did you speak with?
His sister, Kimberly.
And did she provide you information regarding Melissa at that time?
Yes.
Now, I want to take you to December of 2001. 2001. Did you meet with anyone in December of 2001?
December.
With the Fulton County Medical Examiner's Office?
Okay, yes, December 27th.
Okay. And who did you meet with?
Mary Beth Hopdahl or Hepdahl.
And do you recall why in December you met with her?
To document dental records for Melissa Wolfenberger.
Now, are these dental records that you received?
Yes.
In December 2001, did you do anything else with the dental records?
So once they were entered into this document to where they could be placed in the national database, I gave that to one of our communications and records personnel at the police department, so it could be entered.
You said it was put into a national database. What type of national database?
I think it's like NCIC is a program that we have for missing persons or stolen cars or anything like stolen property, all of that. So it's a database where a road officer or any officer can call in a person's ID and they'll note that if they're reported missing or a stolen object or whatever it may be. My understanding of this was that the pathologists or the doctors were able to chart or make some type of notation regarding dental records that could be entered in this. So if another agency had remains that were unidentified, they could cross-reference this and it might help them to pull the cases together to further seek identification.
And did you do that? Did you put her dental records on NCIC?
Yes.
After December of 2001, excuse me, is it in December of 2001 when you put her dental records on NCIC?
Yes, December 31st was when the document that Ms. Hepdahl helped produce was provided to our communications people, who are the persons that would enter it into that system.
After December 30th, 2001, and the dental records are placed into NCIC, when is the next part of your investigation in this case?
March 13th of 2003.
So almost 18 months later again, after the records go into NCIC.
Yes.
What occurred in March of 2003?
Dr. Carol Terry contacted me regarding the records, and I ended up meeting with her and bringing the records so that she could review them.
Okay. And what date is that in March of 2003?
March 13th.
And Dr. Terry, where was she a medical examiner?
Yes.
Where did she work?
Fulton County Medical Examiner's Office here in Atlanta.
You said here in Atlanta?
In Atlanta.
Okay. And when you met with Dr. Terry, did you meet with her at the Fulton County Medical Examiner's
Yes, I
Office?
did.
Was there anyone else present with the two of you when you all met?
Mainly the two of us. We were in their office, so there were other people around, but I believe I only recall speaking with primarily her, and if there was somebody else there, they weren't involved in it, and I didn't make any notation of it.
And during that meeting, was she able to provide you with information regarding unidentified human remains?
Yes.
After that meeting on March 13th, did you send anything to Dr. Terry?
Yes, I did.
What did you send to her?
A written copy of the dental records pertaining to Melissa Wolfenbarger
And how did you send that information to her?
by fax.
And after you sent those dental records, did you receive information on the identity of the skull that they were trying to identify?
Yes.
Once the skull was identified, what day was it identified?
March 14th, 2003.
So the same day you sent over the dental records, the same day it was
Yes.
identified? Did you discuss any investigative tools or testing that could be done on the skull?
We talked about DNA testing.
Now, once the remains were identified, just answer yes or no, did you attempt to locate Chris?
Yes.
And did you locate him?
Yes.
All right. I want to take you to March of 2003. Did you have an opportunity to interview Chris Wolfenbarger again?
Yes, I did.
Okay. What day was that?
I don't have a report on that. I don't have a summary for that one, but it was it was at the Gwinnett County Jail. I'm sorry.
Was it close in time to when the head was identified?
Again, I don't have a date, so
Did anyone go with you to interview Chris?
Detective Calhoun,
And where did Detective Calhoun work at the time?
I believe Atlanta Police.
And during that interview, were you the primary person leading that interview?
Yes, I was.
Oh my God. Why do I think this is gonna be a mess?
Like that. Tell the jury briefly about your kind of interview style when you interview individuals.
I mean, every interview that I do, I'm trying to obtain truthful information. So I try to speak to everyone respectfully for one thing, and take what they're providing as factual information until it can be proven otherwise. So I just sit down with a person like I would sit down with anybody in any circumstance and ask them questions and stuff. If it gets to a point where there's some contradictory information or something that appears to be a problem in there, we definitely might confront them about that or go further into detail about it. But for the most part, I try to be, have a good rapport with them and just sit down and ask logical questions and take what they provide as factual information.
Now, when you interviewed him, did you allow him to kind of lock him into a version before telling him whether or not Melissa was found or not?
Well, it was just reviewing and obtaining the history that he provided again, which we did. And then later at the end or near the end of the interview, he was informed that Melissa had been identified.
And was he able to give you a history again of their relationship?
Yes.
Leading up to the last time he saw her?
Yes.
During the course of that interview, do you recall him talking about her father?
Yes.
What, if anything, did Chris tell you about Melissa's relationship with her father?
I think that that they didn't have a really good relationship, that they didn't communicate, I think.
Do you recall him telling you that she loved her father?
I don't recall that.
That's the opposite.
Do you recall him telling you that?
I'm gonna object to the leading.
Heck yeah.
Do you remember asking him whether or not her father could do something like this?
I don't. No.
Sounds like she's giving up a little, John. Says Hilton does seem less stressed out in this trial. Agreed, but I think she's just like,
Do you remember him in this interview again discussing about them trying to work on their relationship in the end or December of 1998?
I don't specifically recall it, and I'd have again. I did review that interview, but I don't recall his exact statements.
Do you remember him telling you about the last time he saw Melissa?
Yes.
What do you recall about him telling you about the last time he saw her?
He stated that he saw her walking from around the train station, and that he didn't initially recognize her, I believe.
Do you remember him telling you when he saw her?
No, I don't.
Do you remember if he told you that this was again in March or April of 19?
This is leading. He doesn't remember it. Now she's answering the question for him.
But I'm asking y'all come here for a second.
yeah, this is the second time you did that, Hilton. So now she tried that on interview 1, and now she's trying it on interview 2 to get into this whole, you saw her, and you notice his answers are actually really helpful for the defense when it comes to the second interview where he doesn't have notes to look at. He said he didn't recognize her at first. Well, that's very consistent with the first interview where he says, I saw her walking and it looked like she may have been on drugs or hanging around, doing things that one would expect might change your appearance. And then he comes out here and says, he said the same thing in the second interview with a little bit more detail, walking around the train station. And Hilton wants that March, April answer.
If you'll please rephrase your question, Ms. Hilton.
Do you recall an interview if it was any months after the last time he had? Do you recall when it was?
I don't specifically recall when it might have been.
And have you had the opportunity to view that interview in its entirety? Or listen to that interview, excuse me?
I did listen to it.
And in listening to that interview, did that appear to be a complete, an accurate depiction of that interview as you recall it back from 2003?
It does.
They didn't ask about Taco Bell. So, because we have Calhoun giving this March, that it was said in March or April of 1999. That's when he last saw her. And that they went out to lunch, they went to Taco Bell. But this guy in neither interview is giving that same March or April.
People have their witnesses available to second. Preliminary examination, September 2nd, 2025, 9 a.m. That is before Judge Perry.
Judge, may I address an issue? Mr. Lucky was staying where the incident, the allegations against him, he was renting a space at 1074 East Forest. He's not allowed to go there. All his worldly possessions are there. He has tried numerous civil standbys. He said he even got a court order that he could get his belongings. Can you be of any assistance, him getting his property from there?
I'm not moving anything, if that's what you're asking.
Pardon me? No, I'm not asking you to help move them. No, not, you know, that. Judge Otis.
Well, ordered it in writing.
Who ordered it?
The one that let me out on bond, I believe Judge Otis. They wrote it down on a post-it note.
It's a Otatella.
I'm
It's a
sorry.
magistrate.
I'm sorry. I didn't have my
I'm
glasses.
gonna tell him you called him Otis, though.
Sorry.
Funny.
Right.
Right.
Like the elevator. You have an order that allows civil standby.
He said he was issuing a written order for me to have access to my property. That's what he said on Zoom when I got bonded out.
Has he issued it?
He said he did. I was in custody. I didn't have a pen, a paper, a case number. I have nothing.
Would that be reflective in the file, Your Honor?
I don't see an order. Mr. Killowall, if you prepare an order permitting civil standby to that address to retrieve his property, I'll sign off on it. I don't know.
Okay.
Sure.
All right.
Nothing.
Huh?
Sheriff's done nothing. I've been there more than 10 times with the owner. There's witnesses.
We'll have a court order.
Thank you.
If he gets a court order, I'll sign off, sir. It'll have to be done today, otherwise I'm out for about a week, so.
I'll have it done this afternoon.
All right.
Thank you.
All right, thank you, Your Honor. Do we set the, oh yeah, we did say.
Also, the court
Wait a minute,
keeps me
hold on.
on my, that address.
Okay, we're gonna take care of it.
September 2nd.
Yeah. September 2nd.
Court calls case, People versus Nathan Gabachi. Tell Otis he needs to do an order.
Andrew Childers, Green on behalf of the people.
Good morning, Your Honor. Alex Warren Green on behalf of Mr. Gabachi. Could you please state your name, sir?
Nathan Gubachi.
Thank you.
Your Honor, at this time, we are asking the court to set the matter for preliminary examination.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available to second.
That's fine, Your Honor.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Freshour. Bonds will continue.
Your Honor.
Court calls case People versus Ashley Nader.
And then people, Your Honor. That's Mr.
Yeah.
Morning, Your Honor. Rob J. Cole on behalf of. Judge, in this matter, we're asking.
Your
that-
name, ma'am.
Ashley Nader.
Thank you.
Nader, I'm sorry, Judge.
No, it's okay.
Judge. Sure.
That was to you or me?
I was just.
You were answering for me, Kilowog?
Judge, I'm not sure where I am this morning.
Okay. All right. Well, that leads to confidence for your clients. Come on.
He wants you to go take ETG, see if you got any alcohol in your system.
All right, in essence, you're seeking an adjournment of these.
No, we're saying preliminary exam.
Exam. All right.
Hold on, just relax.
People would have their witnesses available tonight.
The ninth.
Preliminary examination in this matter will be set in person September 9th. 2000.
I'm sorry to interrupt you, but I have probate matters, 3 evidentiary hearings starting at 9 o'clock. I don't know how long they're gonna go in probate court. It's over money issues. I think they're gonna be long hearings. Can we go out? Is it possible?
Doing the 9th.
Yeah, I'd like to tell you I can't do the 9th. You're gonna be going when?
To the 8th, third day.
30th.
30th of August is fine.
No.
Of September?
Yes, sir.
I'm sure that's fine.
September 30th, 2025. That's at 12 noon. That is before me.
You're gonna go test. You're gonna do that.
What I'm gonna do is I'm gonna order that the defendant go over today. Ma'am, if I give you an ETG, there's some postings that indicate that you're consuming alcohol.
I'm not.
Probably shouldn't post in the fashion those are posted. You need to go over, take an ETG test. I'm also gonna order that the defendant is to be placed on a sober link unit pending further order of the court. Her bond will continue. However, with those in place, I will then allow the defendant to travel to Kansas City September 3rd through the 8th.
Yeah, Judge, the tether will be removed in silver link in place.
What gave you that impression?
Nothing really. I was asking.
Okay. Oh, that was a question?
I was asking.
That'd be a no.
The tether stays.
Tether stays.
Okay. Thank you for your consideration.
Yeah, I understand the disappointment, but she also left the state without permission, seeming not to understand that order, do not leave the state of Michigan. And I did not throw her in solely because of that. So she's lucky to be out and lucky that her only consequence of that has been a tether. Anything else?
No, Your Honor. Was she
Please think
supposed
so.
to report back today after the
No, she
testing?
doesn't need to report back today. She needs to go over, take the ETG test. Well, there'll be an order over there and she needs to pick up her sober.
Okay, thank you, Your Honor.
Court calls case People versus Khalil Haddon,
Joseph and Gilman, people, Your Honor.
And Assistant Public Defender Lamisa on behalf of Mr. Haddon, who is approaching. Mr. Haddon, if you can say your name for the record.
Brian Haddon.
okay, go ahead.
Your Honor, discovery is complete in this matter, and we would be requesting to set it for preliminary exam.
People have their witnesses available the second. Preliminary examination, September 2nd, 2025, 9 a.m. That is before Judge Perry.
Thank you, Your Honor.
That's in person. Thank you. Bond will continue. Court calls case People versus Dwight Williams.
Andrew Childers appearing on behalf.
I'm here.
You know what? What's gonna happen though is I'm gonna call your case and you'll be nowhere to be found. Yes. The third 30.
Is this the way? Judge, can we pass the Mr. Williams matter? He had called me saying he was having trouble getting a ride from Detroit, but he promised me he'd try and be here.
He's not on a bus.
You being a considerate judge you are, I know you'll take that into consideration.
So this is just a delayed bench warrant.
Basically,
Yeah,
yes.
okay.
Thank you.
Yes. Court calls the case People versus Curtis is it Moncanito? Moncanico?
Joseph and Gilman, people, Your Honor.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Mechanical. Sir, could you say your full name for the record?
Curtis Mindro Mechanical.
Thank you. And Your Honor, we are requesting just a very brief adjournment. We haven't yet received discovery on this file. Our support staff reached out yesterday to the prosecutor's office, and I believe we should be getting that very soon.
August 28th, 2025, 9 a.m.
Thank you.
Bond continue. Thank you. Court calls the case People versus Derek Lovely.
Joseph and Gilman, people.
Greater Bird on behalf of Derek Love.
I was wondering where you were. It was not going to be a complete day unless you showed up.
I was thinking the same thing about you, you know.
Your name, sir?
Derek Lovely.
Thank you. All right, you're asking for an adjournment.
Please.
4th or the 11th, sir?
I'm the 4th, please.
4th. Probable cause conference will be set September 4th, 2025, 9 a.m. Bond will continue in this case.
You and your honorable court have a great day.
Thank you. You too. Court does call the case of People versus Michael McLean.
And on behalf of the people, Your Honor.
Lord Yagi, Assistant Public Defender, with and on behalf of Mr. McLean, who's approaching. Could you say your name for the court?
Michael McCarthy.
Your Honor, in this case, I am respectfully requesting that it be set for preliminary examination. My information is, I don't think there's any outstanding discovery.
People have their witnesses available the second.
We'll do our best, Your Honor.
And
Preliminary examination in this matter will be set September 2nd, 2025, 9 a.m. That is before Judge Freshour.
thank you, Your Honor. May I respond briefly? My understanding is this is the only case that is holding my client. He does indicate that he has an alternate place to stay besides with the complaining witness. The date on this complaint is from June 1st. I don't believe there's any allegations of any like bond violations or contact. This was a delayed arrest. So Mr. McLean wasn't arrested at the time of the offense. He was actually in treatment, and then he was completed the first phase of treatment, was out, was not having contact with her, and then was arrested. So I think that shows that he can be out of custody and stay away from her, not have contact with her as he was for at least a few weeks before his arrest.
Your Honor,
Ms. Zenda, yes.
I would be objecting to any modification of bond. The facts of this case are that he was released from jail on 5/28/25 and immediately went to her residence after being released. He was formally served on that date. And then on the preceding days afterwards, he was on her property, hiding on her property. When she would come outside, he jumped out and yelled, "Who do you have in your residence?" He then left and then began leaving her voicemails and calling her. A friend also saw him on her property. So I had concerns given that. I also have concerns given that of his criminal history. He has a previous home invasion first conviction from 2007 and 2022 dismissed home invasion first, a 25 dismissed PhD second, and malicious destruction of a building. And he currently does have a hold outstanding for a domestic violence case with bond set at $500. So at this point, I would have concerns for her safety and communities, and I would ask that bond remain as set.
May I respond briefly?
Sure.
He was released from jail, but there was no contact order at the time he went back to her address. So I just want to clarify, it sounded really bad the way
Yes,
the
it did.
APA.
You were being Zended. Go ahead.
He was not aware of and not served the PPO until afterwards. So it wasn't like he went to her residence after being out of jail and being told to stay away from her.
So he got arrested on what?
If I can clarify, I'm not sure exactly if it's arrested. If I can clarify, he went to the residence on 5/28, was served the PPO that day, and then in the preceding days after he was served the PPO, told he should not be having contact. He went back to her property and then was also calling her. So he was violating that PPO after it had been served and he had been given notice.
Your Honor, he does dispute the timing of that. Obviously, I know this court this is not a hearing date, so I know we can't get into the details. The missed call login discovery shows 5/28 and not after. So we dispute that he made any contact with her after being served the PTO, but obviously that's the purpose of the exam. And so I just wanted to note that.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
Court calls case People versus Ahmed Ajabori.
Ready, Your Honor. Good morning, Your Honor. To you and your staff, Brian Berry, appearing on behalf of Ahmed Al-Jabori.
Thank you.
Sir.
Ahmed Mohammed Al-Jabori.
Thank you.
Judge, today's the date and time scheduled for a PCC. We'd respectfully ask the court to adjourn to September the 9th if possible. The only reason is I have court almost every day.
September 9th?
Yes, Your Honor.
No.
Okay.
I need a green sheet.
I have a green
So
sheet.
you have, I could give you the 4th or the 11th.
Let's see.
Don't usually let people pick their dates, and then you did it anyway and you picked the wrong date.
I did pick the wrong date. Do you have an afternoon docket on the 4th, Judge? I have a sentencing in Wayne County Circuit Court on a murder case on the 4th. And the 11th, I have a hearing as well. I'm sorry. I can.
No. Because so first of all, you being private counsel, chances are you're going to be in the afternoon anyway. I said everything at 9 o'clock, but I'm here all day. So I give you any of those dates, you will be set in the afternoon. Ms. Widely, can you make sure counsel is set in the afternoon? Otherwise, we'll never get done with this case. All right.
Thank you, Your Honor.
I don't know. You're just doing whatever you, which date do you want, sir?
September the 4th is fine in the afternoon.
All right.
Thank you.
Probable cause conference will be September 4th, 2025. I'll set it at 9 a.m., but you'll be in that block.
Thank you, Your Honor.
Notification. Thank you. Bond
Thank you.
continue. Your Honor. Thank you. Court calls case People versus Vandalis Patterson.
Alexander, on behalf of the people.
Good morning, Your Honor. Kerma Dadush on behalf of Mr. Patterson.
Good morning.
Good morning.
I've seen you walking around. You haven't said anything all morning.
Well, you'll hear me 4 more times, hopefully.
Oh, that's a threat. Go ahead.
State your name for the record, please.
Glad to say.
Your Honor, I have submitted a green sheet. We are going to adjourn for mitigation purposes, and whenever there's a chance to address bond, please.
All right. Probably, well, the 4th give you enough time to get something.
I would, if you could, the 11th, that's probably better. It's more time for our mitigation department.
So all she had to do was say no. September 11th.
Thank you, Your Honor.
2025, 9 a.m. But as to bond.
Your Honor, Mr. Patterson is charged with an RNO from 2022. He did fail to appear his last court date.
Well, 3 of them.
Yes.
Yeah, go ahead.
But since 2022, he has had no other cases. He hasn't picked up any charges. He's been working. He has 10 kids now, 7 of whom.
Excuse me?
Sorry?
What do you say?
I said he has 10 kids now, 7 of whom are in his care. What? You want me to continue or stop?
No, I'm stuck on 10, but go ahead.
Okay. He takes care of 7 of them financially. He's gotten himself a job. He works in landscaping and home improvement. He's been at his job for a year. He sincerely apologizes for not appearing in 2022. He's told me that it was a dumb mistake that he didn't. He was immature at the time. He's trying to run away from his problems, but since then he wants to get his life back on track. He's already done so by not picking up new charges and by having a stable job. And he wanted to say something himself as well.
I just want to say I was being mature. I was running from my problems. I didn't want to go to jail at the time, but now I'm ready to face my problems and get on with get my warrants out the way so I can raise my family and have a clean slate.
How did he come into custody?
Truck stop?
At the room, police contact.
What happened?
At the room at Days Inn with my friend. She had the room for her foster care son. He had did something. So they had both rooms and they came and knocked on
Hold
both.
on a second. So you came into custody not because you walked in from 2022.
He did not.
And he's at the Days Inn.
No, it was trespassing because her son was in foster care, but she had the room. They were playing.
You were at the Days Inn when you got picked up?
Yeah, when they came to the room, yeah.
They came to the room?
To the room for her son doing something. And that's
Police contact that is unrelated to him.
Unrelated to me. Yeah. I didn't catch no charge.
And we did talk about him. He should have turned himself in since then.
Yeah, you were. Yeah, it was a big skip, but okay.
But, if Your Honor releases him on his own personal recognizance, it will come every single time.
2028, if his pattern holds.
There will be no pattern.
Well, that's all. So.
Okay. Ms. Zenda would like to speak. Ms. Zenda.
I would object to any modification bond. As the court has pointed out, he did fail to appear in 2022. He also has other holds are set for a 1482 case for an OWI that's up on September 12th. That's a $100 bond. Then a DV out of 14B that's up on September 15th with a $100 bond. In this case, there are 3 RNOs, and when officers went to arrest the defendant on his warrants that he had at the time, he was pulling away, not listening, was taken to the ground, had to be tased, and still continued to be pulled away. And then he also, when they had to get him to the car, he went dead away and had to be carried. So I'd be objecting to any modification bond, as well as with his criminal history. He's got 2 fleeings that he was convicted of, a PVSC that he convicted on, a PV second, an unlawful driving away, and an OWI. So given the fact that he failed to appear for 3 years and had to get picked up, and then the facts of this case, I would object to any modification of bond at this time.
Can I briefly respond, Your Honor?
Give it your best shot.
All of these charges and his past history is from 3 years ago. The 2 cases that he has are $100 cash bond that convert to PR once he's released on this case. So he did PR on those. But all these allegations are from 2022. His criminal history is past that. Again, nothing since 2022. Those other cases, I believe those are also from 2022. So they're not new.
The only reason they're from 2022 is because he didn't turn himself in for failing to appear.
I did say nothing new from 2022, after 2022 since then
Well, there's new things. He just hasn't
appeared.
appeared on those either.
Well,
Two other courts.
they're from 2022. He hasn't appeared on them, but no new charges. since
Because he
2022.
doesn't seem to want to go to court. I do have some
Now he does.
concern that
I
he's
do
at
wanna
the
go to
day's
court.
end, gets picked up at the day's end.
No, it wasn't that. But you guys just hear me out. Can you hear me?
Okay, sure.
I was saying up at the room with my friend. She got a foster son that they was paying for the room. They did something, whatever. That's how I ended up getting picked up. So I didn't turn myself in. Yeah, I understand that.
Yeah, that's the point.
Yeah.
One more chance, Your Honor.
Okay, I'll show up to court. For 5 minutes.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Thank you.
Court calls case People versus Devon Julia Martinez. In Zoom. Oh, yep.
We're ready in this matter. Vaughn Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Devon Julia Martinez. Ms. Martinez, could you state your name for the record?
Devon Julia.
Your Honor, today is a date and time scheduled for a competency review. We have received a report dated July 16th, 2025. Would submit that for the record. Has the court received that report?
I have the one dated July 16th. That's the one that you're talking about.
Thank you, Your Honor. This matter was scheduled last minute. We do not have well, first of all, we don't have any further evidence to present to the court.
Any other evidence from the people?
I reviewed my internal file and I have not seen that competency. I just. Mr. Brown's handing a copy.
It's a determination that she's competent to stand trial. I believe you may not have it in your file because I think Judge Hammoud may have ordered competence. Right. That's 100%, but we received a copy.
Okay, thank God the people have no further.
All right. Based upon a review of that report, the court would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent.
Thank you very much, Your Honor. We will prepare an order to that effect.
All right. And what would you like me to set the next proceeding for?
May we please have a probable cause conference date?
I'll set a probable cause conference for my next available date of August 28th, 2025, 9 a.m.
Thank you very much, Your Honor.
Bond is
Excuse me.
continued.
Sir, what is your name? The lawyer? Sorry, you? What's your name?
Lawyer?
Yeah,
I am Attorney Brown.
Brown, Mr. Brown. May I call you at the public
Yes.
defender's office?
You certainly.
Sure, he's there all the
Please
time.
feel free.
Awesome, thank you.
All
Good
right.
day.
Alrighty, ask for Lauren Brown.
That's
Not Ron.
Ronald Brown. Ron, no.
Thank you. Yeah.
Why would he do that?
Judge,
But
this is him. This has to be my first day in court. Doesn't remind me of this.
Yeah,
It's not the worst though.
Speaker.
you're glad. You're lucky my staff likes you. Court calls the case People versus Collins Fry. I'll call it up with your other one, Mr. Killer.
Assistant Public Defender, let me stop on behalf of Mr. Spry. Mr. Spry, can you please state your name for the record?
Colin Spry.
Thank you.
Oh, I'm sorry. That's it.
Okay, you're requesting an adjournment. At my next date, he's in custody. My next date would be the 28th. Would that be enough time to get the mitigation and try to
Yes, Your Honor.
one more week out?
That'll be perfectly,
28th will work on.
yes.
Probable cause conference will be August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Christopher Atkins. From Livingston. Oh, there, okay. Christopher Atkins.
Yes, Your Honor.
Okay.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins.
You have a camera there, sir, or no?
Yes.
Oh, there he is. Okay, we got you. State your name.
Christopher Roy Atkins.
Thank you.
Your Honor, we're asking for an adjournment. I know Mr. Atkins has been in contact with Mr. Bowling from our office. We are tracking his case in Livingston. He may be sentenced into a treatment court that would kind of help resolve the case here. So my understanding, Mr. Atkins, I looked yesterday, it looks like that was adjourned to the 22nd of August. Is that correct?
Yes, I don't qualify for the mental health treatment court. I think they were trying to get drug court, which is similar. But yes, 22nd is my next court date here. I also have calls here, September. So I have the 22nd call in September. I'm not sure. I haven't talked to my lawyer what we're doing. So qualify for mental health that I was.
Okay. Mr. Atkins, could you, we're going to adjourn today. Can you give our office a call and so that we can talk about what the status of your other case is?
Yes.
Did he say that other one was adjourned to September 22nd? Or
I
August
believe he has
22nd?
I don't want to say a new, but there it looks like there was a case that was bound over, and that's in September. I did not get the date on that. What's your September court date?
I have the September court date is 12.
September 12th. So if we could have a
12th.
date after
The 12th.
the 12th.
Sure. All right. Probable cause conference then, in this case, we'll probably hit right in the middle of those, will be September 18th,
Okay.
2025, 9 a.m. Bond will continue.
Thank you.
All right. Thank you, Mr. Atkins. Call your attorney's office, please.
Thank you, Your Honor.
All right. Court calls the case, people versus Jonathan Faith.
Joseph and Gilman, people.
Good morning, Judge. Lawrence H. Margolis with and on behalf of Mr. Faith, who is to my right. Mr. Faith, please introduce yourself to the court.
Morning, Jonathan Faith.
We've executed a waiver in this matter, Judge.
Why do I? What?
Say it again, sir.
This is-
This is his file. We should wait that he filed today. I understand.
That's a term, right? Oh, he's only, I got you.
Yeah.
I got you. All right, sir, you're waiving your right to a preliminary examination.
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, I do.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, I do.
People also waive the right.
We do, Your Honor. Thank you.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 and 4 following.
Judge,
Your turn, Margolis.
Thank you, Judge. We're in receipt of the felony information. We'd ask Your Honor to enter a plea of not guilty and waive.
Defendant having waived formal reading, pleading not guilty as to all 4 counts, court will enter that plea. Pretrial will be set for
October 15th at 1:30 with Judge Conlon.
October 15th, 2025, 1:30 before Judge Conlon.
Thank you, Judge.
Bond will continue. Thank you.
Have a good day.
You do the same. Court does call the case, People versus Jamie Foxx.
Andrew Childers appearing on behalf of the people.
Good morning, Your Honor. Ellis Friedman on behalf of Jamie Foxx.
What is Judge? Assistant Public Defender, also on behalf of Ms. Fox.
Good morning.
Good morning. Your name?
Jamie Fox.
Thank you.
Thank you, Judge. I have a chance to speak to my client and to her other counsel. On my file, we are requesting this matter be set for preliminary examination.
That's, which one is yours? Is
We believe we have the discovery, Your Honor.
0223.
you want to exam also?
We've been trying to keep the case together.
I think we're ready now.
Okay. All discovery is complete, then
That's our understanding.
people have their witnesses available to second.
Your Honor, I don't think I'll be able to have the private guest up by the second.
Okay. Ninth?
Ninth is good.
Ninth is good. Will that work for you, Mr. Christian?
Fine, Judge.
And hearing no objection from the people. Bless you, whoever that was. Preliminary examination will be set in person September 9th, 2025, 9 a.m. before Judge Valvo in both matters. Bond in these cases will continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, ma'am. I don't know why. Who knows? Court calls the case People versus Delco Thomas.
Alexander, on behalf of the people, Your Honor.
Well.
Mr. Thomas?
Yes.
And you want the adjournment?
Yeah, just. Okay.
Thank you, Your Honor. Stephanie Cannon, on behalf of Mr. Thomas. Mr. Thomas, could you please state your name for the record?
Delco Thomas.
And
Thank you,
we
sir.
are so happy to be here today, Your Honor, and
Yeah.
we're going to ask for a 2-week adjournment of this matter to see if some discovery can be obtained.
All right, I have a little longer than 2 weeks, or I have 10 days.
Your Honor, if we could do a little longer this week, since I was informed there might be exculpatory evidence on the defendant's phone, and that maybe officers are taking pictures of it, so that might take a moment to see if they did or what that is. Your Honor.
Okay. Then.
Your Honor, I do
Given
believe
that, I can do the 4th or the 11th, which if we have it by then. But,
4th. Your Honor, we would ask for the 4th.
We can try something.
all right.
They took it to the flag.
Probable cause conference will be adjourned September 4th, 2025, 9 a.m. Bond will.
Somebody.
Let me see if I can find them.
Thank you. Court does call the case People versus Heather Booth.
Joseph and on behalf of the people, Your Honor.
Donna Adelson on behalf of Ms. Booth.
Ms. Rushing? She's on the other one.
Sorry, Judge, I was on the record in another matter. I apologize.
Not a problem. I called the Booth matter.
Sydney Rushing appearing on behalf of Ms. Booth.
Your Honor, Ms. Booth was going to show up in person. She is actually on her way to Richmond, Michigan to get herself into Sacred Heart. When she was released last, she was supposed to get released into treatment immediately. There were no beds for her, but now there are. I would ask that Your Honor adjourn this case.
You come up with the most incredible stories. Some of them being true, some of them.
Well, actually, I was
Don't tell me
texting with her
you're not
right
gonna
now.
just show me a picture of anybody on a bus.
No buses,
Going anywhere.
no buses. I was asking her to send me proof of her getting into Sacred Heart. She just sent me something. She only sent me her tether thing right now.
Her what?
No, a proof of tether. She didn't send me proof of her getting into Sacred Heart yet. She said it was a telephone call with CMH. and is working.
So she's admitted into Sacred Heart. She's on her way there, you think?
Mhm. Yes, I think.
Your Honor, that was my understanding as well.
Now you have two people telling you that.
What'd you say?
Now you have two people telling you that. So is it more
I have two
probable?
people that talk
rushing
to the
is-
same person telling me that. I don't know that that really bumps that up. Okay, here's what I'll do. I will issue bench warrants for the defendant's failure to appear in these matters. I, however, will not enter those bench warrants until the 19th day, till the 23rd. Well, 22nd is
Okay.
Friday.
Okay.
So if you get that information to them, I won't issue.
Thank you so much, Your Honor.
All right. All right, thank you. What? 10,000 cash sharing. Court calls the case People versus Owen Thurman.
People, Your Honor.
And Alex Warren Green on behalf of Mr. Thurman. Your name, Mr. Thurman?
Olin Thurman.
Your Honor, we are asking to set this matter for preliminary examination.
Discovery is complete.
Believe so, Your Honor.
People had their witnesses available the second.
We'll do our best, Your Honor.
Preliminary examination in person will be set September 2nd, 2025, 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. And court calls the case of the People versus Christopher Taylor.
Joseph DeGalma, people. On behalf of Mr. Taylor, who's approaching, and stands to my right. Mr. Taylor, please introduce yourself to the court.
Christopher Taylor. Thank you.
Thank you, Your Honor. Your Honor, I was fairly recently appointed on this case. We are still working on discovery on this matter, so we're asking for a brief adjournment.
That objection, September 4th, 2025, 9 a.m. Bond continue.
Thank you, Judge. Here, take this.
Court calls the case People versus Cody Wines.
Joseph DeGalma, people, Your Honor.
Assistant Public Defender Sandra White on behalf of Cody Wines. Mr. Wines, can you state your name for the record?
Cody Michael Wines.
Your Honor, I'm asking for an adjournment of this matter. I believe this is the first hearing for further negotiations and to review video with Mr. Wines.
Probable cause conference, August 28th, 2025, 9 a.m.
Thank you.
Bond continue. Court calls case People versus Maz Sharif.
Joseph DeGalma, people, Your Honor.
Morning, Your Honor. Mustafa Houili on behalf of Mr. Sharif, who's to my left. Sir, please state your name for the record. Maz Sharif.
All right.
Your Honor, today's a day for PCC. There are two cases in this matter. There is a felony larceny and a unlawful driving away of a motor vehicle. Your Honor, he was arraigned last week. At this point in time, we've only received paper discovery on the larceny. We haven't received any discovery at all on the unlawful driving away. So I'll leave it to the discretion of the court judge if you'd like to do an adjourned PCC for us to get up to date with discovery, or if you want to set it out for exam a few weeks out to give us enough time to review discovery and determine what we want to do with the exam.
I don't set exam until discovery is complete. You're telling me discovery is not complete. How much time do you need to get it done?
Judge, we just need the discovery on both matters. They're still outstanding, maybe a couple weeks.
That objection, probable cause conferences will be adjourned September 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Have a good day.
Thank you. Court calls case People versus Douglas Wren.
Joseph DeGalma, people, Your Honor.
And Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Wren, who's approaching. Mr. Wren, could you state your name for the court?
Douglas Wren.
Your Honor, I have been in communication with the people on this matter. There's no offer available, and so I do believe discovery is complete. We would ask that this be set for exam.
People have their witnesses available September 2nd. Preliminary examination in person, September 2nd, 2025, 9 a.m. That is before Judge Fresh Hour. Bond will continue.
Thank you, Your Honor.
Court calls case for the people versus Mary Collins. Collins, I think is.
On behalf of Mary Collins, who's approaching the podium. Ms. Collins, can you get up here, please state your name for the record?
My name's Mary Collins.
Thank you.
And one just says the date and time set for probable cause conference. We are working on mitigation, so we ask for a brief adjournment at this time.
Without objection, probable cause conference will be adjourned September 4th, 2025, 9 a.m. Bond continue.
Thank you, Judge. Bye, Mary.
Court calls case people versus Zaria Brand.
Hey, Alexander, on behalf of the people, Your Honor.
And Lori Yagi, Assistant Public Defender, with and on behalf of Ms. Brand. Ms. Brand, can you state your name for the court?
Zaria Brand.
All right, I have before me a plea sheet that indicates that defendant would be pleading to count 3, domestic violence, a 93-day offense. Upon her successful plea, counts 1, 2, and 4 would be dismissed. Defendant is agreeing to pay full restitution, and there's a sentence agreement or recommendation to sentence under 7694A. That's the court's full understanding of it.
And that's correct.
Yes, Your Honor.
All right. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Zaria Brand.
All right, ma'am, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will.
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
Seriously? Of course, hold on one moment. Here we go. On the date of May 19th, 2025, at the location of 755 Campbell Avenue, apartment 12, Ypsilanti Township, Washtenaw County, State of Michigan, what do you do on that day involving a Marquise Maddox that makes you think that you're guilty?
I threw a nail gun.
You threw a what?
A nail gun.
You threw a nail gun
Yes.
at him?
In the direction of him, yes.
Were
It never made contact.
okay, good. But you were intending to place him in some apprehension of that contact happened?
Yes.
Yes, all right. And who is this individual to you?
My son's father.
Ma'am, I would have to advise you that if I do accept your plea, if you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, any sentence evaluation, in this case, the court would no longer be bound by, and you would not be able to set aside your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1, 2, and 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
September 22nd at 10 a.m. Judge Washington.
September 22nd, 2025, 10 a.m. That is before Judge Washington. Bond with its conditions will come.
Your Honor, I apologize. May I address a bond condition?
She's out.
I understand. She does have a tracking
That to be
tether.
changed?
No, Your Honor.
Okay. Go ahead.
She does have a tracking tether. I believe she's had one since May. Is that right? Since she was arraigned on May 20th, which is the date after the incident in this case.
After she threw the nail gun?
Correct, Your Honor.
Okay, go ahead.
There's, to my knowledge, been no bond violations. Ms. Brand works. She's a working mother and she's in school. So she's starting her semester in just a few weeks at WCCC studying psychology. And so she has a very, she's very goal driven and focused and wants to become.
Is she at Wayne County or Washington?
Washtenaw. Did I?
Yeah, you include one too many C's for Washington. You've done that like 3 times already. It's okay.
Thank you for correcting me. I apologize. Okay.
You're welcome.
WCC.
Yes.
Okay. And she, so she would ask, given her lack of bond violations and her close supervision, now that she's pled guilty, she understands that any misstep, any violation will not only compromise her liberty in terms of going to jail, but it will also compromise her record and her future career in terms of losing 4A. So I would ask if the court would consider removing the tether.
Response.
Your Honor, at this point, I would object. I think it's something that could be addressed in sentencing, but given the facts of this case, I would ask that the tether remain at least until sentencing.
Sorry. What I'm gonna do is, I'm gonna let Judge Washington's probation department make a determination after they at least interviewed her before that tether is. So at this point, I'm gonna deny your request for a bond.
Understood, Your Honor. Thank you.
Thank you. Court does call the case People versus Dominique Brewer.
Camera Dadush with and on behalf of Mr. Brewer. Please state your name for the record.
Dominique Brewer. Thank you.
Your Honor, we're just asking for a short adjournment, please. About 3 weeks, if Your Honor is willing to do so.
Probable cause conference, September 4th, 2025, 9 a.m. bond.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, sir. Court calls case People versus Andre Brooks.
And then on behalf of people.
Assistant Public Defender Chelsea Virgil, and on behalf of Andre Brooks, please state your name.
Andre Brooks.
We'd like to set a preliminary exam.
Discovery is complete.
I believe so, Your Honor.
You will have their witnesses available the second. Preliminary examination in person, September 2nd, 2025, 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the People versus Eric Buckner.
Ready next.
Joseph and
On Brown, Deputy Chief Public Defender appearing with and on behalf of the Buckner who approaches the podium. Mr. Buckner, state your name for the record.
Eric Buckner.
Buckner, at this time, we're respectfully requesting an adjournment of a little over 2 weeks. Mr. Buckner has medical appointments. He also would like to be able to decide.
Sorry. He has medical appointments?
Yes. Have.
Will the 4th work?
Yes, 4th, please. You need to see the.
Probable cause.
But just proof of his medical. He's got 3.
That's
Okay, all right, thank you. My word.
probable cause conference, September 4th, 2025, 9 a.m. Bond will continue.
Danny, may we address just one aspect of the bond? He is out, but he's on home confinement. He has a lot of these medical appointments. They're going to vary, they're going to change. Just asking that the bond be changed to maybe a GPS so that he can go to work as well. He does need to be able to work to be able to pay his rent. He's got bills that are coming up. The home confinement prevents him from doing that. But mostly it's the medical appointments. He has 3 verified appointments that are coming up very soon. He's going to have more after that. So we're not asking that he just not have any kind of supervision, just a different kind.
I would indicate, I guess, I don't need a response necessarily from the people given that request, but what I would do is I'm going to leave the home confinement in place, making an exception for a verified medical. We just need to turn that into community corrections.
Okay, can he also do employment too? Because the home confinement prevents him from even working. He's got to be.
A response regarding the employment. Is that, I mean, for employment to actually work or
Yes.
for interviews?
No,
I actually have a job, Your Honor.
he does have a job.
I have a job.
Your Honor, what is the definitive of verification of that employment?
Okay, he's got something here.
All right, so what I would do, Mr. Brown, if you prepare an order, get it over to the prosecutor's office, and it had to be today. For my signature allowing his attendance at the medical appointments as well as employment.
Okay.
I will sign off on that. That can get over to community corrections.
Thank you very much, Your Honor.
Thank you. And September 4th, bond will continue with those changes. Court calls the case People versus Maurice Burgess.
Andrew Children appearing on behalf of the people.
What's called?
Burgess. Our prep row. Somewhere, Scooby.
I apologize, Your Honor. Lori Gaffey, Assistant Public Defender with and on behalf of Mr. Burgess. Could you state your name for the court?
I'm Maurice Burgess, Your Honor.
Your Honor, may we approach on this matter?
Is there really a need?
There's a lot of updates that I've been talking with Mr. Burgess about, and
Is that to the use of recreational marijuana, which he's not supposed to do, or to the cocaine? Which is the update?
Well, it concerns both, Your Honor. It concerns all of the steps that he's taking, and specifically the documentation that he went to Home Division yesterday, and we are waiting documentation, and
Documentation for what?
that he did his intake at Home Division yesterday.
As well as CMH.
As well as CMH. And he came in with a written plan in his notebook. And I can honestly say I did not even tell him to do this, but he came in with a written plan about how he's going to stay clean.
If I test him today, is he gonna test clean?
Yes, sir. But I won't in 2 days. Your Honor.
What?
Your Honor, I'm not lying to you. Judge Simpson, I've done everything that I could possibly do to make sure that I can continue to stay in society. I have a job. I start tomorrow at Full House Restaurant on Eagles. I went to CMH and did my intake. I also went to Home Division and spoke with Mr. Marcus, who is a recovery coach on E-Course. All these places are within a half a mile from each other, from the hotel living now. So I'm in position to lose my room, my residence, as well as my relationship with my fiance, who's clean and clinging on by her fingernail, because I'm trying my best to do my best and change my lifestyle, sir.
What are we doing with this case?
So I do have a green sheet, Your Honor. This is a case that is from, I believe, 2022. It's a possession. And I would ask to adjourn it because I'm hoping it comes to some sort of resolution. The bottom line is Mr. Burgess knows that he needs treatment. And I've had a lot of conversations with his fiance and him, and I really do think they are very active in making sure that he gets help, stays out of trouble. He just got this job. He has the sweatshirt that he's wearing. And he's eager to prove himself. And I think he's very genuine when he says, I mean, he asked me to ask this court to let him prove himself and to show with his actions that he is following up, that he's good to his word. I did call Home Innovations this morning and verified Mr. Marcus. I'm just waiting for his email response to come through, that he did actually go to the meeting yesterday. I did verify with his fiance who is with him that he did that, and that he is clearly not using, he came to court to knowing that he had this bond violation, knowing what he risked in terms of his liberty, but he wanted to do the right thing and he wanted to stand before this court to ask for the opportunity to show that he can be clean, he can be sober, he can be in the community, and he will do the right thing. He's very eager to prove himself. He has no other cases, not on probation or parole, and he has this new plan.
Recovery coach, a new plan. a new
Oh, and he's going to
residence.
Little House meetings, multiple times per week.
I start work tomorrow, y'all. I just need an opportunity to prove to you that I can do the right thing. I know I've made some mistakes, some horrible decisions. I'm 62 years old. I'm old enough to know right from wrong. And I apologize for my shortcomings, but I'm trying to do the right thing. I can't prove it to you from there.
I have 4 positive tests. He's been using cocaine. It almost less than a week ago, I have a positive test regarding that.
I understand.
He doesn't have a valid medical marijuana card. He's also been using marijuana or THC at least in the system. You're telling me now, the day before he's to come to court, he's now in treatment.
I started
And
yesterday.
somehow or another, I'm just supposed to say all of that's okay.
Well, Your Honor, he knows it's not okay. I think what makes him really different is he is coming, he is testing, and he is doing his best. It is obviously a struggle for him to battle his addiction, but he is not getting in trouble. He's going to meetings. He's doing the best that he can. And I think he's doing what, especially on his own initiative. I mean, I was surprised yesterday because he doesn't have his own cell phone. He shares with his fiance. And before I even talked with him, he came up with this plan himself. And I think that goes to show that he is taking the initiative to do this himself. And he is using this added accountability of testing. He knows that he's going to lose his liberty if he tests dirty one more time. I mean, he knows that. And he knew that coming into court today. And he still came in anyways, because he wanted to prove to the court that he is willing to take that chance. And he said, the court certainly will revoke my bond if I test positive again, but I'm not going to, because I'm serious and I'm serious about recovery. And so I would ask this court for one more week, one more opportunity for Mr. Bergens to prove himself.
I can do it, Your Honor. I promise. I'll be locked up if I don't. I can't do anything from jail. I have a job now, and I want to prove to myself as well as the court.
Anyone can do jail.
Sir?
Nothing.
I'm sorry.
I'll adjourn this out to the 28th, 2025 at 9 a.m. I don't need a response from the people. Defendant's bond is revoked. If you send me the proof that he's enrolled, I'll reconsider the revocation of his bond. But until such time, his bond's revoked, defendant's remanded. All right, something. That's a bad. Court calls the case, People versus David Davis.
Stephanie Cameron, on behalf of Mr. Davis.
How come Ms. Saab has your sheet? What?
She's way more efficient than I am, Your Honor.
What?
She's way more efficient than I am.
Oh, I know. I was so happy to see her today.
I know. Your Honor, in this particular matter, we are simply, I'm sorry. He threw me. We are simply requesting a 2-week adjournment. Because he was sitting here just as patient, doing this thing that he does like this, staring at me.
Ooh.
Mr.
Okay,
Allen.
so first of all, do not flatter yourself. He wasn't staring at you.
He was.
All right, now.
With expectation that I hand over the green sheet, Your Honor.
Oh, okay, whatever.
So, Your Honor, we're simply asking for a 2-week adjournment in this matter for possible plea negotiations.
Sir, your name?
David Davis.
Thank you. How long did you need?
We're just asking for 2 weeks. Or I understand the court is not available in 2 weeks potentially, so at the court's earliest convenience.
See
how we do.
September 4th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Thank you. Court calls the case people versus, is it Eric Davis?
Alexander on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Davis. State your name.
Eric Davis. Eric Davis. Thank you.
Your Honor, I have a green sheet for the court. We are requesting an adjournment to, so I can review discovery with my client.
Probable cause conference, September 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Samuel Freeman.
Assistant Public Defender Chelsea Vergils on behalf of Samuel Freeman. Your Honor, I received communication from Mr. Freeman this morning that he's a dialysis patient and he had a dialysis appointment and ran a little late. Would you consider passing the case to allow him a few more minutes to appear? I believe he's on his way here.
Said that so nicely. She did? Denied. No, I'm kidding. All right. I'll pass it. Let's see if we can get here. Between you and Kilowald. Court calls the case people versus Lamia Gresham.
Alexander on behalf of the people, Your Honor.
Chelsea Vergils with on behalf of Maya Gresham.
Is Lamia. See, no.
I'm not positive.
I always put, I put it, I put it in the wrong place.
Hi, I'm Maya Gresham.
My apologies again.
You're okay.
All right, thank you. That was so nice. She just said, you're fine, Judge. It's okay.
Your Honor, we're asking
Not like
for,
anybody else being critical. But it's okay. I'm sorry. Go ahead.
Your Honor, we're asking for a preliminary exam in this case.
Discovery is complete.
To the best of my knowledge, Your Honor.
People have their witnesses available on the 2nd.
We'll do our best, Your Honor.
All right. Preliminary examination in person, September 2nd, 2025, 9 a.m. That is before Judge Freshour. Bond will continue. Thank you, ma'am.
Thank you.
Thank you.
Court calls the case of the people versus Jennifer Gray.
Joseph Pagano, people.
Assistant Public Defender Ben Dunaway on behalf of Ms. Gray. And could we approach the bench?
Your name, ma'am? No, they can come on.
Jennifer Gray.
Thank you. All right, the court will pass this matter, ma'am. Have a conversation with your attorney about a possible.
Hi, Luke. Good morning. Good morning. Okay. Traylon Hill, Mr. Burbank. Traylon Hill.
I had a new offer.
Oh.
Got a plea rejection here. If you'll sign it, if not, I'll send it on.
Okay.
And I'll put the offer
Did everyone get a copy of this latest?
Sign this right here, Trail, and this is rejecting the offer.
Is this on the first president? It's mandatory, right?
Not mandatory.
If you want to go to trial and not accept a plea agreement, then listen to your attorney and do what he's telling you to do.
Okay, so basically it's completely off the table right now, the plea,
Yeah.
right there, and there.
What is, what's all
It's
this?
defamation, man. They've been gaslighting me for 5 weeks straight. Been doing my best to get to the population going on and try to stay out of trouble. They all look on the microphone.
All right, this is, stop talking. This is cause numbers 24 DCCR 1500, 24 DCCR 1614, 1615, 25 DCCR 0436, and you're Traylon Hill. And Mr. Hill's charged, let me go through this, in cause number, the first one, 1500, with obstruction or retaliation. Do not do that again.
My apologies.
Who's in here for him?
My grandmother.
All right, ma'am, can you move over to that back corner so that he cannot see you and be distracted? Thank you for being here. Mr. Hill, you just don't know how to behave, do you?
I apologize.
Saying you're sorry doesn't matter. This is nonsense. Since we were here last time, I don't even know how many more pages of the nonsense that you've been doing in our jail.
It's gaslighting. It's solicitation.
Okay.
And I've been trying my best to stay out the way. I've been getting bullied over the microphone. I have inmates there encouraging the inmates to harass me, calling me punk, alpha, profit, you know, plenty of things. Gangster play, mad.
Yeah.
Mortar. Man, I'm just trying my best to stay out the way.
Okay.
I got a job. I got a home. An actual home. I don't stay in apartments or anything like that. My mama actually owns rent houses. And you know what I'm saying? I'm actually trying to take care of the family business. My dad's 76 years old.
Yeah.
My business stay out the way.
Well, it doesn't look like you are.
Yeah, it's tough in that facility. It's a war zone.
So one of the time you're running back and forth, playing like a little kid in the day room.
I work out.
Who made you do that?
I'm a boxer. I work out.
Are you allowed to do that in the jail?
In the rec room, yes.
Okay, so are you allowed to do it in the other room?
I have a one-man cell in the facility.
Are you allowed to do that?
Yes, ma'am.
You are?
I'm not running freely throughout the facility or anything like that, but I do work out a lot every day.
So who made you dash the floor with water?
Everyone in that facility has a water
Who
bottle.
made you dash the floor with water?
I'm not the only one. That was
Listen
me.
to my question.
No one did.
No, but you did it on your own,
Yeah,
right?
it was
Nobody's
okay.
stop talking when I'm talking. I'm going to ask you some yes or no questions.
Okay.
So nobody's making you do those things, right? Nobody bullied you into dashing water, right? Yes or no?
Yes, ma'am.
Okay, hold on a second. What about why do you continue to make comments to the female officers out there? Why do you think that's okay after you've been told not to do that?
Sitting in the cell all day long, man. When I see them women, I get the burden. I'm a little bored. I admit that.
'Cause you're a lover boy.
Yes, ma'am.
So you understand that part of all of this trouble and you not being able to get your cases worked out is because you can't follow that rule.
Yeah, I hate that.
Did somebody bully you into being that way to those officers?
In a manner, you know what I'm saying?
Oh,
When
yeah?
you're dealing with these stressful inmates, you know what I'm saying? I love to be around mom.
Okay.
Mama boy.
Judge, based on his Sunday night activity, I'm pretty sure there'll be a new case coming.
Yeah.
I've got to call into the investigator for the sheriff's department to find out
Okay.
when they'll bring that over. But I would ask that we go ahead and set these in for trial.
And we've already talked before about the fact that everything that's happening, a jury is going to know about all that. You understand that? Okay. And do you think that's going to help you or hurt you when a jury hears how you're behaving in the jail?
When it comes down to video footage and how I explain it, I think my efforts will be pretty good.
You think so?
Yes, ma'am.
You think so? Let's go through real quick before we do this rejection. And cause number 241500, you're charged with obstruction or retaliation. Is that a third?
That is a third, Your Honor.
Third-degree felony, which means if you're found guilty, the range of punishment is between 2 years and up to 10 years. Do you understand? And cause number 24 DCCR 1614, you're charged with aggravated assault with a deadly weapon. And second-degree felony offense, which means the punishment range is between 2 years and up to 20 years in prison if you're found guilty. Do you understand that?
Yes, ma'am.
And cause number 24 DCCR 1615, you're charged with aggravated robbery, which is a first-degree felony, which means if you're found guilty, the range of punishment is a minimum 5 years up to life in prison. Do you understand? And then in 250436, you're charged with burglary of a habitation, which is a second-degree felony. The punishment range in that is between 2 years and up to 20 years if you're found guilty. Do you understand? I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison on a lesser offense of robbery.
Of robbery and dismiss all the other charges.
You have every right to reject that.
It was an excellent deal, but
That's fine. I just want you to know that after today, I will accept no plea agreements. A jury is going to decide because I don't know that I even agree with this. So today's the day. If you want to take it, fine. If not, you're going to trial. A jury will decide if you're guilty or not. And then if you are found guilty, that jury will determine what your punishment is. And is that what you want to do?
all these charges going to be on one trial?
They don't necessarily have to be because you've got three different dates.
Your Honor, the robbery and aggravated assault are the same offense day. I'd expect to try them together.
Okay, so what can happen is you will, it sounds like the aggravated assault and the aggravated robbery will be tried together. It's important that you understand also, if you're found guilty on those, then the state can also try you later on one or both of the other cases. If you're found guilty on those, because the offense dates are different dates, there is the possibility that any sentence that a jury gives you could be stacked or run consecutively. Do you understand? Okay. All right, we'll get it set for trial. Go back with the bailiff. Good luck, Mr. Burbank.
Thank you, Your Honor.
I don't know that I've ever been so mad at a defendant. Can't help it. Kevin Ross, Mr. Burbank.
I mean, you know, we started.
Yeah. It's gonna keep on getting worse because the jury's gonna. And there's no paperwork on Mr. Ross, right?
I do have a bond request.
Oh.
You said something wrong? No, I don't want you to turn around.
He said, how are you doing?
Oh, yeah. How you doing?
Good morning, you're Kevin Ross?
Yes, ma'am.
And so Mr. Ross has two motion to revoke probations, cause number 24, DCCR 1198 on probation for the offense of a deadly weapon in a penal institution, and in 24 1199 evading arrest or detention with the use of a vehicle. Mr. Burbank has filed motions asking that I set bonds in these cases. Give me just a second to get this pulled up.
Judge, if I may, just.
Yeah, go ahead.
Inform the court, we have discussed this at length, Mr. Burbank and myself. I have made several requests to DPS via my investigators to bring the new evading. Typically, we could proceed on a motion with just a probable cause affidavit. The alleged egregiousness of this evading lends to an absolute need for the video, which is what Mr. Burbank wants. Considering DPS has not brought that, I feel like in fairness, I cannot oppose a bond for this defendant because I think that the video itself will be dispositive of either he was driving or his brother was driving, is my understanding. I've made requests of the trooper and they just have not brought it in. So June 13th.
And if I may
Can't
add,
imagine why it would
Judge, I
be.
will represent to the court, I do have an affidavit from another individual, but I need the video because we could really shortchange it. I mean, get right to the problem.
Who's the trooper?
And I'll try to reach out again.
I'll reach out this afternoon after docket. So I'll figure, it looks like there are other allegations.
Sorry, Judge.
And so,
Garcia. Jordan Garcia.
I'm sorry.
Jordan Garcia, I seen Judge setting us up on that.
In addition, Your Honor, I just,
Yeah.
in my motion, I also add, if you were to consider a bond, some other requirements that I believe would be necessary.
And I've spoken with his probation officer and she understands the situation.
So we've got allegations of the evading with a vehicle and just an evading on June 13th. And then possession of marijuana from June 13th as well. And then drug patch, tested positive for cocaine. Out past curfew, June 13th at 1:39 a.m. Okay.
I have the PC on that today, Judge, if that would help.
I think I might have it right here. Let me take a look at that as well. Here's what I'm going to do today. I'm going to hold the motion to set a bond. We're going to, I'll contact DPS as soon as docket is done to see what it takes to get that video. If we can get it quickly, then everybody can look at that and see where we are. If for some reason we cannot, then I will reevaluate and set bonds at some amount based on the nature of the allegations and all of that. So, but
Mr. Faye's reach out as well, Judge.
Okay.
This morning, while you're on the bench,
Okay.
they can get-
if you'll let them.
When they know the court is.
If Detective Bates will let them know that he's gonna call them or I'm gonna call them, so maybe they can get that very quickly. And we'll go from there. All right, go back with the bailiff. At the most, we'll reset it for a couple of weeks. But if we get that, then we'll figure it out as soon as we have an answer today. I'll get with both of you. Okay, go back with the bailiff. And then you have Carrington Scott.
I can announce if you don't want to.
No, we need to get them out, please. Oh, okay. Have we seen or heard from you? This is Mr. Smith's case on Carrington Scott. Good morning. Are you Carrington Scott? And this is 25 DCCR 0538. Mr. Scott's charged with robbery. Mr. Burbank?
Your Honor, I have reached out to Mr. Smith. I understand what's going on. There is a video that is missing, and he was attempting to try to get it. The court can do two things. It would probably be dispositive of this case if it received, it's a convenience store robbery, and some of the cameras were missing.
Okay.
The tape. If you want to reset it for a couple of weeks, I don't know when Mr. Smith will be back.
I'm sure Ms. Malfino or Mr. Nichols can
We
step
can
in.
handle it, Judge, and I just want to let the court know, Mr. Smith has documented that he did reach out to the detective on August 12th. I'll be happy to follow up.
Okay, thank you, Ms. Malfino.
It's a
So we'll
missing
just,
Convenience store video. Some of it was already erased, so I think I agree it would be dispositive.
okay.
Be dispositive of it. I mean, he's rejected the 15 years from Mr. Rojas, Judge.
All right, we'll just do maybe about 3 weeks. That'll give Mr. Smith, when he gets back, or Ms. Malfino, sounds like she'll step in and try to take care of getting whatever information they can, so that we'll, if they have it, you can see it. If they don't have it, then we'll figure it out from there as well. All right, thank you, Ms. Malfino.
I think that's all I have.
It is. Thank you, Mr. Burbank. Mr. Lewis, you have Derek Ardwan. It's a sentencing. Good morning. Good morning. Are you Derek Ardwan? And Mr. Ardwan was previously in court in cause number 25 DCCR 0350, entered a plea of guilty to the second-degree felony offense of sexual assault. The agreement was for a cap of 6 years in the institutional division of the Texas Department of Corrections. I have received the pre-sentence report. Has everyone had an opportunity to review that?
We have, Judge.
Any additions or corrections?
None from defense, other than something I'll clear up on argument.
Okay. Go ahead.
Well, Judge, when you review the PSI, it's several times Mr. Ardwan does take responsibility for what happened, for his actions. I know there was some talk from the PSI writer that seems like he was minimizing or still deflecting some of his responsibility in what happened. I did speak to Mr. Ardwan about that. He said that toward the end of their interview, he understood more what the PSI was saying, because there was 2 people from probation there at the time. Yes, sir. And so as the second person started to intervene, he understood, and so he totally takes responsibility for what happens. He understands the situation. He shouldn't have been in, him or the complainant, during that situation. He was going through, he was going through a situation with his girlfriend. It wasn't his wife. It's not his actual stepdaughter. His girlfriend, and started getting more attention from the stepdaughter than he should have, and he went along with it. Shouldn't have, but he did. It wasn't a situation where someone was underage or anything like that. She was definitely of consenting age. Being in a relationship with him, they started hanging out a lot more, almost in a dating scenario, if you will. And then it escalated to the point where they worked together that evening. Nothing of force, anything was happening. To my client understanding at the time, he thought everything was consensual that was going on. It wasn't until later, until this investigation, that he realized her stance or argument of her being intoxicated to the point where she couldn't give consent, legal consent or anything during the activity. I would like to point out with him, when you look at his criminal history, he has not had any type of criminal history since 2001. So since he was in trouble that one time or that last time there, he has done everything he can to try to keep his life on track and not revert back to any of the old activities he had when he was younger. My understanding is, he does have a lot of family support. I've been in touch with several members of his family that have reached out to me. My understanding is that the mother of the complainant is still very supportive of it. And to the point where, even though he moved out and was away from her and everything like that, she still wanted to pursue their relationship and work on their issues. He is asking that the court consider community supervision in the situation. I think it definitely could be appropriate here in a situation where he's a registered sex offender at this point, so he will be able to get any of the attention or that he needs through any sex offender classes or through their registration, as well as I think that there's several vehicles available through probation that could help with any other additional issues that he does have. So at this point, Judge, we are asking the court to consider deferred adjudication in the situation with Mr. Adelson.
Thank you. Ms. Malvino?
Judge, although the PSI reflects that they were unable to contact the complainant, the notes in the case reflect that our office has, and she seemed cooperative and wanting to go forward with the prosecution based upon that, based upon the nature of the offense, the circumstances that even Mr. Lewis himself has described with respect to, she may be considered a legal adult, that the difference in their age is quite substantial. Obviously, he took advantage of the fact that she was making bad choices with respect to drug and alcohol use and got herself in this position. So on her behalf, Judge, the state would argue for the 6 years under the cap, but defer to the court's discretion, of course.
Thank you.
And if I just may confirm, in case the question arises, he has already completed the sex offender registration paperwork.
Oh, yes.
Yeah,
Yes,
I think we did that at the
Plea.
plea. Mhm.
Just check.
Thank you. So I guess my thought is on this, I don't disagree with Ms. Malfino that prison time isn't necessarily warranted. It sounds like you got yourself in a predicament that you're way old enough and grown up to know better. She wasn't a minor. There was a lot of things that looked like they were consensual up until a certain point where y'all probably, it sounds like we're both so intoxicated, you clearly didn't know what was going on. 6 years, you're out in a few years. There's no treatment. There's none of that I think would be helpful. And so I think, to me, the better and maybe even more difficult thing for you is a probation, because this type of probation is not going to be easy. So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. There's two things that are, well, let me finish and then I'll go through some other stuff. I'm going to order a $1,000 fine. I'm going to order that you follow all of the rules and conditions of probation, and that includes entering and successfully completing a licensed sex offender program. To successfully complete the program, you also have to admit what you did. So it's very important that you get in that program, you take responsibility for your part in what happened and how you got to this position so that you're never in this position again. You're obviously already signed the paperwork and understand that you will be required to register as a sex offender. If you don't register timely, then that's a violation of your probation plus another felony offense. And so you've got to take care of everything you're supposed to while you're on this probation. So the good thing about that is it's a deferred probation and there's not a conviction. The good thing for me and potentially Ms. Malfino later is that by doing this deferred probation, that cap of 6 years is off the table. Okay, that's over today. I didn't give you prison time, so that's gone. If you violate this probation, I then have the entire punishment range, which is 2 to 20 years in prison if you violate. So there's no coming back and saying, I want the 6 years or I violated and don't, I've got the whole range. I'll look back at this and I'm sure I'll be reminded at what their argument was, and it's not likely to be 6 or less. You understand? So I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. Now, obviously, a part of this probation is that you have absolutely no contact and no communication with the victim. And so if there's some relationship that you're still having with her mother, it cannot be at a place where she is. You cannot go to wherever she's working. If you go into a restaurant and then she comes in after you, you're the one who has to leave. It's up to you to remain away and not have any contact or communication. You understand? Yes, sir. All right. Good luck. Thank you, Mr. Lewis. Sorry, that goes with that. Mr. Jeffries? Mr. Jeffries, you have Jesus Ibarra. Morning. Oh, good. Good morning. Good morning, sir. You're Jesus Ibarra.
Hey, folks. Yeah, they are at lunch in the Donna Adelson jury selection day 1. Absolutely nothing of interest happened thus far. I assume nothing of interest will happen. So, yeah, I mean, I went in there. I streamed it because I got a few messages. Hey, you need to stream it. All right. Nothing happened. So, folks, thank you all for showing up. You over at X, you on YouTube. I will be sending you over to Flux. That's all I have for you guys. Yeah. See you in the next stream or video, and you all have a good one. Okay? See ya. Bye-bye.